Hi, everybody. This is Hyperwave, and Tyler was on really quickly, briefly this morning with Tone. He may go on again at market close, but today we wanted to talk about the craziness of yesterday and Bitfinex, but specifically the importance. So I'll start off by saying that I am a bit, I've been laughing actually a little bit at the trolls who have been messaging me that this is not a big deal, and I couldn't disagree more. So we will explore why. We have read line by line. Oh yes, I thought it was a good Gonzo journalism shirt day. The most famous quote of Gonzo journalism is when the going gets weird, the word turned pro, I believe. And so maybe there's some fear and loathing in Bitcoin today. But Ty, we're going line by line for the most part. I mean, we read line by line. We're going to pull up some passages. We're going to talk about the importance. There's a lot here that we're going to unpack. Just quick little, snippets. There was $1,000 drop on Kraken, if you guys saw. And moreover, this is the AG. This is the AG. So this is of New York. This is no small deal. And let's look at it. Ty.
Great. Thank you, Leah. What we're going to do is go through this 23-page report. You could and you should do it yourself. But I went through it a couple of times, mainly to learn something that Leah and I have been searching for a year and a half, which is, how does this tether thing really work? And why am I so suspicious of it? And why have we been so suspicious of it to the extent that we told anyone that would listen to us to take all of their money off of out of Tether? And we've been doing that for a year and a half, but I could never find any of the details. How does it all work? We know what it's supposed to do, and we know that most of the time it looks like it's doing it. But what we've never been able to answer are all the questions about the reserves that are supposedly backing Tether, that are supposed to be $1 bill US for each tether. It could also be a bunch of yen. It could be 3 or 4 other things. Well, the Attorney General's office in New York did all of the work for us. Forget what it's doing to the price of Bitcoin. Is it going to go up or down? I don't care. I haven't cared ever since we dropped below 6,000. You know that. And I don't mean to be crass about it, but it's just uninteresting if we bounce back and forth between this price and that price. What is important is to understand the much bigger picture, and that is the ecosystem backing Bitcoin and backing all the other cryptocurrencies. What's it based on? And my conclusion has been that it's built on sand as a foundation, not on rock. And there was one very big rock, which was the Tether Bitfinex BitMEX connection that the Attorney General of the state of New York just turned over. And the Attorney General, by writing up this petition to the Supreme Court of the state of New York, revealed a number of facts that have not come out before. Now, they haven't been proven to be facts, but I would suggest to you that the research done is extensive. And I will show you why I say that. And then we will see what happens with the Supreme Court coming back and responding to this request by the Attorney General's office. So what I'd like you to do is just sit back and listen. I'm going to give you a synopsis of what I think are the important items. I'll tell you what page they're on. You can mark them if you would like to, but I do suggest that everybody just download this themselves and just take time. Don't go in with a preconceived notion. I did not. I have been very suspect, as I've said, of what is going on and why it's so important, and why I have personally not told any clients to buy or sell any cryptocurrency on any exchange, because I did not trust any of the information we were getting, because they're all unregulated. So let's just start with who and what this is all about. This was filed by Brian M. Whitehurst, and he is affirming under penalty of perjury the following. Now, Brian Whitehurst is the Assistant Attorney General in the office of Letitia James, who is the Attorney General of the state of New York. So this is a petition by the Assistant Attorney General under perjury by this affirmation. So you know, number one, they're going to be very careful about what they say in the next 23 pages. Okay, here is what they say that I think is relevant. The petition itself is very brief. It's only 2 pages long. They're petitioning the Supreme Court of the Supreme Court of New York to act immediately. And the action that they want immediately by the Supreme Court of New York is to basically freeze all action on the part of Bitfinex and Tether. And I will explain what that means in just a second. And the reason is because they need to do further investigation, and they can't do it if there's a moving target. What that technical term is, they want to preserve the status quo. The status quo is Latin, which means the current condition. They don't want it to change. So they're asking for 6 things. Number one, they are asking for an order granting preliminary injunctive relief pursuant to GBL 354, and I'll tell you what that is in just a minute, under New York State statutes. A preliminary injunctive relief, freezing in order to maintain the status quo to avoid continuing future harm to New York investors. Okay, that's what they're looking for. And to do that, they identify the respondents. The Attorney General is the plaintiff or the petitioner. The respondents are iFinex Incorporated, which is incorporated in the British Virgin Islands with offices in London, Hong Kong, and Taipei, and other locations worldwide. Also, the respondents are Bitfinex North America, Inc., BFXNA, Inc., and BFXWW, Inc. worldwide. So those are Bitfinex Inc. and Bitfinex worldwide, North America and worldwide, which are, they claim, wholly owned subsidiaries of iFinex Inc., also incorporated in the British Virgin Islands. There is, according to this statement, Bitfinex North America contracts with clients in the United States, and Bitfinex WW worldwide contracts with non-US clients. Bitfinex North America is registered with the US Department of the Treasury as what is called a money transmitter under the Financial Crimes Enforcement Network. So Bitfinex North America has registered with the US Department of the Treasury. Okay, now another one of the respondents is Tether. It's called Tether Holdings Limited, also incorporated in the British Virgin Islands. It's the holding company of Tether Limited, Tether Operations Limited, and Tether International Limited, all of which are believed to be incorporated in Hong Kong. So those are the parties involved. It's not one or two, it's about 8 different respondents that are being petitioned by the Attorney General to do certain things. And we'll get to those certain things in just a second. Based on the information provided by the respondents, Tether entities are owned and operated. All of those entities we just named are owned and operated by the small group of executives and employees who operate Bitfinex, the same people. Bitfinex and Tether have a total of several dozen additional employees around the world. Now, this is a billion-dollar, multi-billion-dollar operation operating out of a number of cities, a number of countries, through a number of various corporations that are all owned by a very small number of people that are the same people that operate Bitfinex as well as Tether. The AG has reason to believe, I'm quoting, that certain of those individuals are or have been located in New York. They wouldn't make that claim unless they had evidence, but that evidence will be presented if the Supreme Court of New York accepts this petition. Based on information obtained by the Attorney General of those respondents, Bitfinex and Tether, Tether is majority owned by an entity named DIG, D-I-G, or DIG Finex Inc., which is also the majority owner of iFinex. So it's getting a little complicated, but they're all the same people. Okay. According to documents obtained by the Attorney General, at various times in 2017 and 2018, both Bitfinex and Tether maintained accounts at 2 New York-based commercial banks, Signature Bank and Metropolitan Commercial Bank. All right, let's jump down to the Bitfinex trading platform. There are today more than 130 different trading platforms available to exchange virtual currencies worldwide, according to the Attorney General. 130 different trading platforms. These have not registered under state or federal securities or commodity laws. Nor are these generally applied standards for operations, disclosures, surveillance, or other investor protections. over 90 virtual currencies are listed for trading on the Bitfinex platform. Bitfinex is one of the relatively few virtual currency trading platforms that allows traders to deposit and withdraw fiat currency, including US dollars, euros, pounds, and yen. It is important, the Attorney General states in this filing, that Bitfinex has sufficient US dollar deposits on hand to fill withdrawal orders submitted by traders. It is important, the Attorney General says, that Bitfinex has sufficient US dollars in deposits to fill withdrawals. So that's the basis of what they are getting into. Prior to August 2017, a year and a half ago, Bitfinex had few or no restrictions on who could access their trading platform, meaning that New York-based investors were able to create accounts. In August of 2017, Bitfinex announced it would no longer permit US individual investors, but US-based business entities were still permitted. That's August 2017. In August 2018, 7 months ago, Bitfinex ostensible exclusion of US-based individual investors expanded to include US-based entities. So a year after 2017, where US individuals could not use this platform, but companies or entities could, they were excluded in August of 2018. Those investors are known as eligible contract participants as an exception to that rule, ECPs. And the Attorney General has reason to believe that several US and New York-based ECPs, eligible contract participants, continue to transact on the Bitfinex trading platform. The Attorney General has reason to believe that Bitfinex still allows New York-based individual investors to deposit, trade, and withdraw virtual currencies and engage in other transactions. That's number 25 on this list. It's on page 6. The Attorney General believes that even though they were supposedly excluded 2 years ago, that New York-based individuals still can deposit, trade, and withdraw. Okay, now they turn to Tether. The primary function of Tether as a company is the issuance of a virtual currency called Tether. Tether is listed on several dozen virtual currency trading platforms. In the case of Tether, one Tether is always supposed to be valued at $1 US. We all know that that is no longer true. Even as of last night, we know that it dropped to 85 cents last year. Prior to February 2019, 2 months ago, Tether represented on their website and in documentation that every outstanding Tether was backed by and thus should be valued at $1 US. That was as of 2 months ago. Tether represented to investors that every Tether is always backed 1-to-1 by traditional currency held in their reserves. In March, on March the 4th, a month and a half ago, Tether changed its disclosure, representing that every Tether is always backed by their reserves. But then they went on to say, which include traditional currency and cash equivalents, and from time to time, other assets and receivables from loans made by Tether to third parties. So as of about 6 weeks ago, Tether came out with a new disclosure that says what they have in reserves needs not be backed by $1 bills or by other currencies, but can be also backed by other assets and receivables, including loans by third parties. That is the important part of why the AG is taking this action. You will see why in just a second. Tether are one of the most prominent and widely traded virtual currencies. And according to their website, there are 2.6 billion Tether outstanding. Therefore, $2.6 billion in reserves. Until November of 2017, Tethers were available for purchase directly from Tether website by New York investors. From November 2017 to December 2018, purchases of Tether could be made only via the Bitfinex trading platform. The Attorney General has reason to believe that during this time, New York investors could and did use Bitfinex trading platform to purchase, sell, and exchange Tether. So that's point number 2 in the AG's request for an injunction against Bitfinex and Tether. On November 3rd, 2018, 5 months ago, having learned of the Attorney General's communications with these groups, Bitfinex and Tether, counsel for Bitfinex and Tether affirmatively contacted the AG's office on November 3rd to discuss the investigation. Okay, so that's the last 2 years, going right up through November of last year. The Attorney General starts looking into it, and the counsel for the 2 respondents, Bitfinex and Tether, sit down to discuss on November the 3rd, about 5 months ago, with the Attorney General's office. The counsel are 2 law firms, Morgan Lewis in New York and Steptoe and Johnson in Washington, D.C. They informed the Attorney General they represented Bitfinex and Tether jointly. So now we've got 2 law offices involved with the Attorney General back in November of last year. And now it starts getting really squirrely. Now we see the sand that this whole operation is built on. Because the Attorney General asks for a number of things from the attorneys about both Tether and Bitfinex. And they list everything they wanted back in November of 2018. They served subpoenas pursuant to Article 23A of the General Business Law, which is the Martin Act. I'm not going to go into what the Martin Act is. Tone has covered it before on his judicial review with a number of different attorneys, but it's general business law, executive law 63, and civil practice law. And on November the 27th, the Attorney General subpoenaed Bitfinex and Tether to provide documentation. On November 30th, 3 days later, counsel accepted service of the subpoenas. December 21st, a month later, the Attorney General requested a meeting with the counsel to occur in early January 2019. council counter-proposed a meeting in February 2019. 2 months later, to accommodate them, a meeting was held on February the 21st, 2 months ago. Okay, so that's how the lawyers got involved. They were served subpoenas by the Attorney General for all kinds of information. They delayed it until 2 months ago. And then, according to documents provided by the Attorney General, by September of 2017, Bitfinex and Tether were using a Puerto Rican-based entity named Noble Bank International to handle their accounts. This is a review of the problems that Tether and Bitfinex had with various banks that was turned over to the Attorney General's office. The respondents ended their banking relationship with Noble in October of 2018, last year. As of early 2019, Noble appears to no longer be in operation. The banking group that they were using all of a sudden stopped the relationship, and it appears they've gone out of business. In November of 2018, Tether announced publicly that they established a new banking relationship with Deltec Bank and Trust, headquartered in the Bahamas. Tether also represented that USDT in the market was fully backed by US dollars that are safely deposited in our bank accounts. A copy of Tether's announcement is attached in this exhibit. However, at no point known to the Attorney General has Bitfinex or Tether disclosed to clients that they have used third-party payment processors to handle client withdrawals, nor have they disclosed who those payment processors are. This is as of yesterday. According to the counsel for Bitfinex and Tether, in 2014, Bitfinex began a relationship with a Panamanian entity called Crypto Capital. According to documents, the Attorney General found out that Bitfinex had placed $1 billion of commingled customer and corporate funds with Crypto Capital. And just an aside here, this relationship started back in 2014, and according to the Attorney General's office, in parentheses, they are believed to be a Panamanian entity that's called Crypto Capital. The Attorney General, after 2 years of looking into Bitfinex and Tether, still hasn't been able to answer the question, where is Crypto Capital actually set up or headquartered? It's parentheses believed to be a Panamanian entity. As explained to the Attorney General by the counsel, no contract or similar written agreement was ever entered into between Crypto Capital and Bitfinex or Tether. So there's nothing other than a wink and a handshake. There are no contracts, according to the counsel for Bitfinex and Tether. Okay, all of a sudden, Bitfinex struggles to fill client withdrawal requests due to Crypto Capital's loss or theft of approximately $850 million. So what happened? Supposedly $1 billion of money that you gave Bitfinex and Tether ended up in some place, $1 billion, and when people tried to withdraw it, it apparently 850 million of that $1 billion couldn't be found or wouldn't be transferred. Documents provided to the Attorney General demonstrate by mid-2018 Bitfinex was having extreme difficulty honoring its clients' request to withdraw their money from trading because crypto capital, which had never been discussed with any of you on the website or in any documentation, this platform, because crypto capital, which held all or almost all of Bitfinex's funds, refused to process customer withdrawal requests and refused or was unable to return any funds to Bitfinex. That's a year ago. You wonder why the Attorney General and many, many other regulators are looking into all of this. It's just that the New York Attorney General has made the most progress by sitting down with counsel for Tether and Bitfinex. Now, I'm not going to go through who these mysterious people are. Merlin, a senior executive at Bitfinex, quote unquote, Merlin, Merlin, and a crypto capital individual by the name of Oz, OZ, in parentheses. The OG obtained a number of emails between the two of these parties, one from Bitfinex and one from Crypto Capital, covering the period of April 2018 to early this year. So for the last year, there were a number of correspondences using public emails that now the AG has between Merlin from Bitfinex and Oz from Crypto Capital. Remember, Crypto Capital has got $1 billion of your money, which is supposedly being held in a safe bank, dollar for dollar, with all of the tether that has been issued. In early October of 2018, rumors began circulating that Bitfinex was close to insolvency, as numerous clients reported that they were unable to withdraw their money from the platform. On October the 7th, 2018, Bitfinex published a notice to investors ensuring them that the company was not insolvent. And then they show exactly what they said on October the 7th, and it's attached to the filing. Similarly, a week later, Bitfinex published a notice to the market stating, "It is important for us to clarify that all cryptocurrency and fiat withdrawals are and have been processed as usual without the slightest interference." They made that public. Number 66 on the filing petition to the Supreme Court states that statement was untrue. It was a lie. Documents provided by to the AG by the respondents show that during this time, Bitfinex was having severe problems processing client withdrawals. The very same day as the notice to the market set forth above, October the 15th, the senior Bitfinex executive Merlin wrote this to Crypto Capital in an email. "I have been telling you since a while, too many withdrawals waiting for a long time. Is there any way we can get money from you? Tether or any other form? Apart with Crypto Capital, we are running low in cash reserves. Merlin, please help. I know we are following the banks. We post as many as we can and let them process as much as possible. We push them, they push back with account closures without reason. Dozens of people are now in waiting for withdrawal of capital." And then he goes on and on. So the statement made by Bitfinex publicly was obviously untrue. Documents provided by AG by the respondents also demonstrate that the loss of funds continued to threaten Bitfinex's ability to uphold its obligations to investors through the end of 2018. And then Merlin begins to get very impatient. I need urgently some funds. We need at least $100 million within the next week. The situation looks bad. We have more than 500 withdrawals pending, and they keep coming in. On and on and on and on. I'll let you read it. Please do, word for word. So all of this nonsense that you hear by the trolls, that this thing is just FUD, goes far, far beyond that. And it's important for you, each of you, to understand it's only 23 pages long. It'll take you an hour to go through, read each word very carefully so you see what the truth is about Tether and Bitfinex by going through this document. Now, here's where things get very dicey. Number 68 on page 15. According to documents provided to the Attorney General and by statements made by counsel for the respondents, an individual at Crypto Capital told senior Bitfinex executives the reason $851 million could not be returned was because the funds were seized by governments in Portugal, Poland, and the United States. Based on statements made by counsel for the respondents do not believe Crypto Capital's representation that the funds have been seized. The counsel and the respondents do not believe that that is true. In other words, Crypto Capital is lying about the fact that that $850 million was seized by the United States, by Portugal, and by Poland. According to the documents provided and based on statements made by counsel for the respondents, $851 million remains inaccessible to Bitfinex. Now things really get juicy between the attorneys and the AG, the two attorney firms, one in DC and one in New York. Bitfinex and Tether have engaged in undisclosed, conflicted transactions to cover Bitfinex's losses by transferring money out of Tether's reserve funds. In an in-person meeting on February the 21st of this year, 2 months ago, counsel for Bitfinex and Tether explained that in order to make up for the apparent loss of $851 million, Bitfinex and Tether were in the process of contemplating a transaction that would permit Bitfinex to draw upon Tether's cash reserves on an as-needed basis up to $600 or $700 million. In other words, the money at Bitfinex, the losses that they had through Crypto Capital, was going to be made up by the reserves that are supposedly backing all of Tether. When asked by attorneys for the Attorney General whether the contemplated transaction would constitute a conflict of interest, counsel characterized the impending transaction as arm's length without providing justification for how that could be the case. At that meeting, counsel did not inform the Attorney General of the terms or schedule of any repayment for when Bitfinex planned to draw on the Tether funds. Council's disclosure at the February 21 meeting. Now, this isn't talking to executives of Bitfinex and Tether. This is talking to the council for Bitfinex and Tether. Council's disclosure at the February 21 meeting raised serious questions about the viability of Bitfinex as an ongoing concern. The possibility that Tether's cash reserves would be dissipated and unrecoverable, and whether Bitfinex and Tether have misled their clients, including both clients of the Bitfinex trading platform and holders of Tether. On and on and on after that. That tells you why this has been filed 2 months later and looking for an injunction by the Supreme Court to freeze everything having to do with the operations of both Tether and Bitfinex. And then in conclusion, the Attorney General does seek to enjoin the respondents from taking any further action to access, loan, extend credit, encumber, pledge, or make any other similar transfer or claim between Bitfinex and Tether in order to preserve the status quo. All right, that's a lot of stuff. I just wanted to give perspective. This is only one rock that has been turned over in the crypto ecosystem, but it's probably the biggest rock. All of the things the SEC has been doing have been fairly obvious. When things like Quadriga take place, everybody acts very quickly. When there's obvious fraud, the SEC has brought charges and even closed down an exchange offshore. But this is the first time that the guts, the essence of the movement of money between and among exchanges based on this multi-billion-dollar operation has had a light shined on it. For years, people have been asking for audits. Law firms have come and gone over and over again. Banks have come and gone. CPA firms have come and gone. And we still have never seen an audit of what is really going on at Tether. Well, we are about to see it, because I don't know if the Supreme Court in New York is going to grant this petition, but I would be shocked with the depth of the discovery in the petition that this does not go forward. What does it mean for the price of Bitcoin? Is it going to go up or down? Are people going to buy Bitcoin to get out of Tether, causing a spike? I don't know. I don't care. I don't have any Tether. I don't have any Bitcoin. Not because of Hyperwave, which was just a signal for me that something was very wrong after we had gone to unbelievably high levels because of some kind of over-optimism that causes a hyperwave. So from that point on, in December of 2017, I have basically said, stay out of all of this until we can clean up the ecosystem, clean up the exchanges, clean up the movement of money, get something under some sort of regulation so we don't have to have petitions like this that take years to develop in order to clean up the mess for us. If we can't do it ourselves, if those of you that are playing in the altcoins, just trying to scalp a quick buck here and a quick buck there, want to keep doing that, it is simply going to prolong this process, according to Leah and me and others, that believe that we have a long way to go before this is ready for prime time. Now, nothing I have just said has anything to do with Bitcoin. Bitcoin is not involved in this. There is nobody to be involved in Bitcoin. There are no executives. There are no law firms. There are no contracts between banks, CPA firms, and Bitcoin. Bitcoin stands on its own and none of the others do. And until we can get to the point that the world in general differentiates between those things, the regulators, the attorney generals, finance ministers, central banks, institutions, hedge funds are proper to be reluctant, which means that the few in the space that are trading between each other are simply trying to take money from each other, trying to time this short-term move up to 5,600, this move down to 5,000, the move from 3,000 to 4,000, 4,000. All of that is just nonsense with you fighting with each other, trying to outdo each other, grabbing money from each other. You are not taking it from the rest of the world. You're not taking it from investors. You're not taking it from banks or hedge funds or institutions, except in a tiny, tiny amount with 2 or 3 or 4 that jumped in before they really understood what they were doing. And we need to get that resolved. The reason I'm bringing you such detail today in what the New York Attorney General is saying and doing is to give some perspective on the span of this at least unethical, at least immoral, and possibly illegal activity that has been going on every day for years, and it's got to come to an end. And with that, I thank you very much. And I think Leah is back. Leah, do you have anything you want to add or any questions?
I think you covered everything, Ty. I'll have to digest all that as well, since we never talked prior and you were quite thorough. So I think we're good. Thanks so much, Ty.
Okay, very good. Thank you, everybody. Please get the report and read it carefully.
Bye, everybody. Thank you.
Bye-bye.